everybody. Thank you very much for listening to me. For those of you, you all know me actually. So I'm a private client solicitor at Hill & Abbott Solicitors. Just to tell you a little bit about myself, I have been at Hill & Abbott for about 9 years. I don't look old enough, I do know that. I started off in litigation actually, and that was where I was intended to be until I went into private client work, which is wills, trusts, dealing with estates when someone passes, and I sort of found myself, if you like, and never looked back. So hence that's what I do today. I'm a private client solicitor. I'm actually a specialist, which means that I'm a member of the Society of Trust and Estate Practitioners. So I can put a TEP at the end of my name, which differentiates me from everybody else. And I do it because I love it, frankly. But what I'm going to talk to you about today in my 10 minutes is just a little bit more about what I do. So give you a bit of an insight, perhaps tell you things that you may not know about wills, powers of attorney, estates, and really, like I say, open it up at the end if anyone's got any questions. So with wills, there's very much a structure. There are certain people who you will appoint to be the people that sort it out, so the executors. You need to determine what assets are going to pass by way of the will, and also who is going to benefit. Now, once you have identified those three people, you've effectively got what a will is, okay? It has to comply with the Wills Act, so a little note on a piece of paper. I've often had clients that email me on the way to the airport saying, by the way, if anything happens to me, I would like this to happen. Unfortunately, it's not signed, it's not a will, so it's not effective for those purposes. Interestingly, not all assets actually pass by way of a will. So things like a joint bank account, property that's owned as joint tenants, that passes automatically to the other joint owner. So not actually by way of your will. So you can't gift your share in a joint bank account because actually it would automatically pass to the other owner. Life insurance policies are written in trust. Those would pass to your nominated beneficiaries. Death in service, again, that's a discretionary payment that your company makes, so you nominate who you want to benefit, but again, it doesn't pass by way of your will. Some things you may not know about wills. Marriage. If you get married, brilliant, everyone's very excited. It does revoke your will though. So if you already have a will, or if you intend to get married, you should do your will in contemplation of marriage, which means that it won't be revoked by your marriage, or you should come and review your planning. The reason being is that it's obvious that when you get married, your priorities may change, so you should really review your testamentary planning. If you have children, one other reason that a lot of people make a will is because they want to make sure that their children are looked after in the event of their passing. Now, whoever is on the birth certificate, so i.e. has parental responsibility, that will be the natural guardian. So if you separate from the partner with whom you had children, whilst you can say in your will, I don't want them to be the guardian, unfortunately, they are the natural guardian, so there would have to be a very, very good reason as to why they wouldn't be the person who had the children's guardianship, so bear that in mind. If we don't have any guardians, so if something happened to both parents, if there is no wish in the will, the court has to think about who would be the best person for the children to go and live with. So if there's no guidance in any kind of document, you're leaving it really to chance that the court will have to appoint someone. And if you have foreign property, I'm very happy to go and examine it, make sure it is appropriate. But actually, if you have land in another country, I can work with the jurisdiction in the UK, but I can't impose my law on Barbadian property or anything like that. So you generally, if you have foreign property, so land in another country, you should really have a will in that country that you have that property in as well. So if you don't have a will, I have a handout. So there's a very set list as to the people who would benefit if you don't have a will. It may not be the people you think it's going to be. And if there is no one, then you might end up giving it to the Crown. Because the Queen hasn't got enough money, has she? So have a quick look at that. But those are the intestacy rules. That means who benefits if we don't have a will. If you're married and have children, the first 250,000 would go to your spouse. Everything over and above that split between spouse and children. So interesting. Not always what we want to happen, particularly if we've got a property that's worth 500,000. You might just be giving your spouse your share in the property. That might be it. So yeah, a bit sobering thought, some of that. Anyway, we've got to move on to powers of attorney. I could talk for absolutely ages, so I probably won't get on to talking about estates, but that'll be like a to be continued part. If you have a power of attorney, one of the biggest misconceptions is that is between wills and powers of attorney. So powers of attorney, you are still alive. Wills are when you die. Powers of attorney, you are still alive. And it is the document by which you appoint someone to look after your affairs. Now that could be financial, or it could be decisions with regards to health and welfare. There are two different types of power of attorney. And it is to cater for should you ever become mentally incapable. So that's, you lose your capacity to make a certain decision. But it is never black and white. There is a lot of grey in the middle. So someone can have the capacity to make a decision as to whether they have an operation, but may not be able to determine how much something costs or whether they should expend their money on that. So every decision is effectively assessed on its merits as to whether someone could have the capacity to make that particular decision. With a financial affairs power of attorney, it's not necessarily always when you lose capacity either, because it can be used at your direction. So if I broke my leg, if I was in hospital, well, there's no suggestion that I don't have my capacity. I could say to my attorney, can you go draw me out some money from the bank? That's absolutely fine, because that attorney is acting at my direction. So they're doing what I've asked them to do. So it's nice and flexible, okay? Now, in terms of the decisions that are covered for financial affairs, it's a really important document because the person can do anything that you can do. So that includes making investments, that includes spending your money, that includes running a bank account, that includes selling property. So when you pick your attorneys, you've got to be really careful as to who you pick, because they could be doing anything that you can do. A bit of a thought. And with health and welfare, it's to do with treatment decisions, and you have to be very specific about whether you authorise your attorney to make certain treatment decisions about life-sustaining treatment. So you either say that you do or you don't give your attorneys that power. Now, Jehovah's Witnesses, to give you an example, would not want blood transfusions to take place. If you have a power of attorney for health and welfare, the person who you appoint as your attorney, if the doctors came to them and said, patient A does not have the capacity to make this decision, do you consent or refuse to this blood transfusion? If they refuse, their authority stems from that document. So it's an absolutely a valid decision. If they consent to it, or if they refuse to it and the doctor does it anyway, it's technically a battery. So actually it would be illegal for them to act against that legal authority. So that's why you get lots of cases in the courts of protection of people challenging whether or not someone should have that kind of decision. Okay. So I've kind of given you a bit of a whistle-stop tour through wills and powers of attorney. So you're all still awake, which is good. Just checking. Obviously it's a really, really big area, so there are things that I haven't covered, but it just starts you thinking about whether you've got things in place to make sure that whatever happens, whether it be losing capacity or whether it be death, that you've got the necessary provisions in place to make sure that your welfare is looked after, and also your loved ones don't have the emotional heartache of trying to deal with that whilst also trying to look after you. Okay, well I think I've got my 10 minutes. Is it well timed?
Yeah, on the dot.
There you go. So has anyone got any questions at all? Yes.
If you've had a will made,
Yes.
and you know it's all sort of valid at the moment, but
Yep.
you maybe want to reappraise it or maybe take out another one, can you go to a different solicitor
Yep.
and take that will and say,
Yep.
this is what I've got, but I want to sort of make a couple of amendments? Can you just
Yeah,
do that?
I do will reviews as part of what I do. As to what you're changing will depend on whether you're advised to have a new will or whether the old one is fine and we just do a codicil, which is a document which is read with the will, but it imports certain minor changes. So if you want to take someone out of your will, depending on how much they were going to benefit, you might be advised to do a new will, because the old will, if you have a codicil, is still sent to probate, so someone would still know that they were in the will and then they were taken out. So sometimes you might be advised to do a new will, but if it's increasing a legacy from £2,000 to £3,000, that should be fine in a codicil, because it's a very minor change.
You can go take that will to another
Absolutely.
solicitor.
Absolutely, because they're separate documents.
It's okay.
Yeah.
Thank you.
Just a quick one.
Yes, go ahead.
I haven't got a will.
Okay.
But looking around, you get such a variation of prices.
Yeah.
I mean, one bloke quoted me £3,000 to do one will,
Yeah.
and yet another person's quoted 250 quid. So
Yeah. There's a lot of varying prices. The things that you should think about is who's going to be drafting it. So if you go to a solicitor, you obviously get the benefit of their expertise, and also they have insurance. So if they really do get it wrong, then there is a recourse if that happens. A lot of companies do off-the-shelf products, so they'll sell you a trust, and they may not necessarily be a solicitor, they may be a will writer, they may be somebody else, but sometimes they have product, compartmentalise their thing into a product, so they will sell you effectively a trust. I don't know, without seeing that trust, whether that's going to effectively meet your purposes, but I do see a lot of off-the-shelf trusts which are sold on the basis that it's going to protect your house if you go into care. Now, I never do anything that I can't, be 99% sure that I can guarantee would be the case. And if I wouldn't do it for my mum and dad, then I wouldn't do it for you. So it comes down to, differences in expertise and what people are selling things for. I give you a service, I don't really sell you a product. It's the difference, really.
Sorry,
Yes.
just to say, what do you think of these wills where they say you can do it yourself? These you can buy it over the counter.
Yeah.
My mum keeps on about she'll do her own one, and I didn't think there was a lot of validity to those.
You can do it yourself, you absolutely can, as long as it complies with the Wills Act. And that is the caveat, really. It has to comply with the Wills Act. If you do it at home and it isn't done correctly, then it wouldn't be a valid will, in which case it's not worth the paper it's written on. So there's nothing wrong with doing homemade wills, as long as you know what you're doing. But there are requirements that you would need to comply with. Otherwise, like I say, you might as well write it on the back of an envelope and it would be just as valid as if you write it in a will. Okay.
Thank you.
Okay. Thank you.
Thank you very much.
No problem.